Good morning, everyone. Welcome to WorkCover Queensland's Common Law webinar titled Redundancy and Reasonable Management Action. My name is Hannah Staunton. I'm a lawyer at WorkCover Queensland and I'll be your host for today. Before we get started, I'd like to acknowledge and pay respect to Queensland's elders, past, present and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters and community. Today's webinar will run for approximately 45 minutes to 1 hour in length, and we'll have some time for questioning at the end. If you need to leave a bit earlier, this session will be recorded and we will send a link of the recording out via email early next week. It will also be uploaded to WorkCover Queensland's YouTube channel. Please feel free to submit any questions during the webinar using the panel on the right-hand side of your screen. As said before, we'll aim to answer some of your questions after the main presentation if time permits. I'd like to introduce our guest presenters for today's webinar from HopgoodGanim. I'd like to welcome back Anna Hendry, one of the partners of HopgoodGanim's insurance practice. Some of you may remember that Anna guest presented for us back in August 2020 on the topic of calculating quantum for a common law damages claim. Anna has been a WorkCover Queensland panel solicitor since 2011 and recently was recognised as a leading Australian practitioner included in the Best Lawyers 2021 and 2022 edition for personal injury litigation. And our second guest speaker, new to WorkCover, I'd like to give a warm welcome to Adele Garnett, who is a Senior Associate in HopgoodGanim's Workplace and Employment Practice. Adele advises on a multitude of reasons or areas including workplace relations, awards, enterprise agreements, policy and legislative interpretation, misconduct issues, training and development, recruitment, grievance and complaint management and performance case management. Her knowledge areas are definitely on point for this topic. Before I hand over to Anna and Adele, I'd just like to remind our listeners that any advice given or questions answered today by WorkCover and HopgoodGanim is general information and only and should not be taken as legal advice. I will now pass over to Anna and Adele to get the presentation started.
Thanks, Hannah, and it's so lovely to be back with WorkCover's audience today. As a WorkCover panel lawyer, I'm often the first person who an employer speaks to after a common law damages claim is lodged. Obviously, that's a stressful time and employers typically have many questions. Questions about the process, questions about the likely outcome, and questions about the costs involved. But the thing that I see time and time again is questions about the interaction between workers' compensation law, which is my playground, and industrial relations and employment law, which is definitely not my playground. With many employer questions relating to the termination of employment during a workers' compensation claim. And so often the interaction between workers' comp law and industrial relations and employment law is an uncomfortable one, with some tension and some mismatch that makes strategic decision-making difficult for employers. So when I read the recent decision of Scott against the Workers' Compensation Regulator, which looks at the concept of reasonable management action, a construct of the Workers' Compensation and Rehabilitation Act, in the context of redundancy, which is an intrinsically IR-based concept, I was straight on the phone to my IR phoner friend, Adele, to get a better understanding of what the decision really means for employers. And that's what we'd like to speak to you about today, starting with a recap of reasonable management action exclusion and the concept of redundancy, followed by a deeper analysis of the intersection of those concepts as set out in the Scott decision, and finally some practical takeaway points. Just as a refresher, psychiatric injuries arising out of reasonable management action taken reasonably are excluded from the definition of injury pursuant to section 32 subsection 5 of the Workers' Compensation and Rehabilitation Act. That exclusion is in place to ensure that businesses can make reasonable management decisions and enact those decisions without fear of lawsuit. Management action, of course, does not encompass every interaction between an employee and their manager. To borrow the words of Deputy President O'Connor in the matter of Reid against the Workers' Compensation Regulator at paragraph 10, management action contemplates a particular type of action by an employer and something other than a mere requirement that the worker perform his or her duties. A similar concept can be found in section 5A of the Safety, Rehabilitation and Compensation Act, which is the Commonwealth workers' compensation legislation. That section excludes from the definition of injury one which is suffered as a result of reasonable administrative action taken in a reasonable manner. The Commonwealth legislation uses administrative action in place of the term management action, but the concept is the same, and we can draw guidance from the Commonwealth case law. In particular, administrative action is described in the matter of Commonwealth Bank of Australia and Reeve at paragraph 31 as, it is not action with respect to the duties that an employee is employed to carry out that is the subject of the exclusion, but action with respect to the employee as employee and his or her employment relationship with the employer. And that's exactly what redundancy is, right? It's action by the employer to bring about a change to the employment relationship, that is the termination of that relationship. So it seems on its face that redundancy is precisely the type of action that is the subject of the exclusion in section 32 sub 5 and that is designed to be protected by that exclusion. Let's look now more closely at the concept of redundancy before we consider the interaction of reasonable management action and redundancy.
Thanks, Anna. It's Adele here, and thank you to WorkCover for having me today. So I'm going to just go through a basic understanding of what redundancy is. I have referred here to the Fair Work Act, which is generally applies to private sector employers. However, the provisions are quite similar in Queensland legislation, the Industrial Relations Act, and then also you will need to refer to the relevant awards and enterprise agreements that apply. So redundancy is defined in section 389 of the Fair Work Act, and there are really essentially three requirements that you'll have there. It's the 1A, 1B, and then 2. So it says a person's dismissal was a case of genuine redundancy if the person's employer no longer requires a person's job to be performed by anyone because of changes in the operational requirements of the employer's enterprise. And 1B, the employer has complied with any obligation in a modern award or enterprise agreement that applied to the employment to consult about the redundancy. And then the third requirement, which says it's not a genuine redundancy if it would have been reasonable in all the circumstances for the person to have been redeployed within the employer's enterprise or an associated entity. Now, there's a lot of nuances in those words, and I could spend a long time talking about all the different parts of that, but that's just a basic understanding of what we need for our purposes today, and we'll go through some of it in a bit more detail as it applies to the Scott case. So one point I would like to make in particular, which is relevant to our discussions, is in situations of major change, there is that requirement to consult. So that's 1B there. All awards and enterprise agreements have clauses which require an employer to consult with employees and which describe exactly how you consult. It's essential in any redundancy process that an employer refers back to that industrial instrument, which might apply to determine how exactly that consultation process should be undertaken. And as will be seen in the Scott case that we're going to be discussing later, if there is any doubt about whether you should consult or not, we just always recommend that you assume that you should consult with an employee before making a final redundancy termination apply. I just thought that it would be very briefly useful for us to go through what employment law claims someone might make, because these operate in tangent potentially at the same time as a WorkCover claim. And you do need to, as Anna has already pointed out, you need to keep your finger in both pies. You need to keep your eyes on both an employment law claim and a WorkCover claim, and to ensure that you have your business risk in mind. So I'm just going to give you a very high-level summary. The main risk is of an unfair dismissal claim, which needs to be made by an employee within 21 days of the dismissal to either the Fair Work Commission or the Queensland Industrial Relations Commission. If an employer can show that a dismissal was a case of genuine redundancy, so meeting those 3 criteria we spoke about earlier, then employee is not entitled to make a claim of unfair dismissal. So it's a jurisdictional argument in legal terms. There are often disputes that need to be resolved by the Fair Work Commission about whether the dismissal meets these 3 requirements. But if an employee can show that the redundancy didn't meet these 3 criteria, then they get through that first hump of the jurisdictional argument, and then they move on to whether they have an argument then about whether the dismissal was harsh, unjust, or unreasonable generally. So the next risk of claim is under the general protections regime for adverse action. And again, this is these types of claims are very similar in Queensland jurisdiction and in the Fair Work jurisdiction. So for this type of claim, an employee needs to show that the dismissal was for some ulterior motive. So it wasn't actually just redundancy, but it was because of, for example, some kind of discriminatory reason. So sex, age, disability, or illness. Or another example might be that they can show that it was because they exercised one of their workplace rights. The most common of those is that they made a complaint in their employment, and then because of that complaint, the employer decided to dismiss them. The next type of claim that someone might make is discrimination, and that's quite similar to the general protections claim, but it's made to the Australian Human Rights Commission or the Queensland Human Rights Commission. And in that case, if the employee can show that they've been discriminated against at some point in the dismissal, then they might have some success. So an example of that might be that they were chosen for redundancy over another employee because they had a disability of some kind, or they were a particular sex or race. And then that last claim there is directly related to one of the requirements of for a genuine redundancy, which is about not consulting under an award or an enterprise agreement. So because these are requirements under the awards and enterprise agreements, if you and it's a requirement under the Fair Work Act that you comply with awards and enterprise agreements, so then you will potentially have a claim against you as an employer if you don't consult in accordance with whatever is in those clauses. So as I've said, there's nothing to stop an employee from pursuing one of the above claims. You can't do multiple at the same time, but one of the above claims and then also the WorkCover claim if they suffer some kind of psychological injury as a result of the poor redundancy process. So it's therefore important to keep your eyes on both potential types of claim. I'll just pass over to Anna now to tell us a bit more about the actual Scott case that we're talking about today.
Thanks, Adele. So there's quite a lot of things to keep in mind if you're looking at making an employee redundant. I'm glad I brought Adele along because those 4 dot points on the slide previous are concepts that I'm not particularly familiar with. But let's have a look at the decision, the facts of the decision in Scott against the regulator, so that we can see a practical example of how those concepts of reasonable management action and redundancy intersected in that case. In Scott, the worker had been an employee of the relevant employer since 2003, and he had been employed in a supervisory role since 2010. He had time off work in 2018 and 2019 for a long-term medical condition, and that was a medical condition that was not work-related and certainly wasn't the subject of any workers' compensation claim. During the time that he was off work ill, he was worried about his job security and he had reached out to the employer in that regard. He had also then, in response, received correspondence from the employer that put his mind at ease as to his job security. Shortly after his return to work from that period of illness, he was called into a meeting by the employer where he was told that his position was being made redundant immediately. And thereafter, his psychiatric injury, the subject of the claim, ensued. The relevant question for the Commission was whether the termination of Scott's employment was reasonable management action taken reasonably, such that it fell within the exclusion under Section 32, subsection 5. Without stealing Adele's thunder, I'll give you the spoiler. The Commission went to great lengths to determine the basis of his employment and ultimately decided that it was under the relevant EBA, which imposed a consultative mechanism in relation to matters raised by the employer to increase productivity, efficiency and competitiveness of the business. Clearly, a budget-based decision to make the worker's role redundant fell into that bucket. However, the Commission also found that even absent the EBA requirement for consultation, there might be circumstances particular to a worker that make a failure to consult unreasonable within the meaning of Section 32 sub 5. And here these included Scott's length of service, his earlier concerns about job security, the fact of his long-term illness, and the supervisory role that he held with the employer. The Commission noted that the lack of consultation meant that the redundancy came as a complete shock to him. Now I'm going to hand over to Adele, who will give some more detail about the consultation requirement.
So overall, when you're looking at reasonable management action, one of the really underlying points is whether you've complied with your industrial instrument, and that is sort of your absolute minimum. So this decision went into quite a lot of detail about whether consultation was required under the industrial instruments. The employer thought that the employee was not covered by their enterprise agreement and was not covered by any modern award, and therefore consultation was not required. When the Commissioner, however, considered whether the employee was covered, she looked in great detail at the position requirements, at the coverage clauses of the instruments, and she decided that the employee was covered by the enterprise agreement. And even if that wasn't correct, that he was covered by the relevant award. Look, this is a fairly common mistake that I come across in my practice. I fairly regularly advise employers who do not know whether particular employees are covered by an enterprise bargaining agreement or an award. And it can be very difficult to know in some instances whether an employee is covered or not. In this case, the Commissioner went into great amount of detail, looking at the percentage of the role that was supervisory, how much was on the job, and considering, of course, the wording of these industrial instruments. I personally have spent hours as an employment lawyer attempting to determine whether particular positions are covered. And sometimes that means looking at the history of particular instruments, looking at case law that addresses coverage clauses. So this is a complicated question at times for employers. The point I'd really like to make then is that if you have any doubt at all, it's much safer to assume that the person is covered by the industrial instrument and consult. That's the advice I always give to employers. This case is somewhat unique in that the enterprise agreement we're talking about was actually very old. It was more than 12 years old. So that made that consultation clause was quite unique. However, in around 2009 and in the following years, most awards and enterprise agreements had a fairly standard consultation clause inserted into them, such that the consultation requirements are usually very similar. So therefore, as an employer, if you're unsure, you can look up a modern award. Best if you look up the one that you think might apply, but anyway, you can look up any modern award and you can follow the process that's in that clause. But it is really important to follow that clause to the T. There's quite specific requirements about what you have to put in writing and things like that. Consultation in relation to a possible redundancy does not usually need to be a lengthy process, which is part of the reason why we recommend that you do it in any case. And it can often be completed even in a period of a week or less. We usually recommend that as a minimum requirement, an employee meets with an employer meets with the employee to provide information about the proposed changes in writing, gives the employee a few days to think about it and to get advice if they'd like, and then a few days later meets with them to generally consider any feedback they might have, and then make a final decision about the ongoing employment of the person. One interesting point that was made in the Scott case, and this goes beyond the requirements in the Fair Work Act, was that in that case, the Commissioner said that consultation should have been a part of reasonable management action, even if the position was not award or EB covered. So therefore, you should consult regardless. In some respects, though, this was particular to the case because Mr. Scott was a long-term employee. He had recently returned from sick leave and he had been given assurances about his job security. But it nonetheless speaks to my general advice and to the direction of the QIRC at the moment in these WorkCover matters that you should always consult with employees in cases of major change, particularly redundancy, Look, it usually only takes a few days and it can save you a world of pain, both at Fair Work litigation and also in WorkCover claims. So the next thing I'm going to talk about is just when, what you should consult about. I think that's the previous slide still, sorry. So generally you should consult about any feedback the employee might have about the changes. So ways to mitigate their losses, other potential organisational structures. So perhaps they might have a different suggestion, a potential even for the employee to reduce their hours or change the ways they work, anything basically that they might want to raise. Consultation's got to be meaningful and genuine. It's not just a ticking box exercise. One really important thing to consult about is any potential redeployment opportunities. This speaks to that last requirement of genuine redundancy. This also doesn't have to be really onerous. It's about the employer saying, look, either I don't have any other jobs available at the moment, but if you can think of any, then feel free to let me know. That's sort of one option. And the next option is that I have this list of jobs available. You can say, if you like, I don't think any of them are suitable, but I'm open to your opinion on that. Or you can equally say, look, if you're interested, then we'll look at how we might move you into those positions with some appropriate training. In this case, Mr. Scott unsuccessfully tried to argue that he should have been offered a different position, but that position was already filled by another employee. So even though this other position was less pay, he still argued that he should have been entitled to have that job. The Commissioner found that spilling other positions that were already filled was not required. So he wasn't successful with this argument. But as a side note, the QIRC did say that it was important to offer a person all positions that were available, even if they were lower pay or a different location or seemingly unsuitable for some reason. This is really because you don't know the person's circumstances and it's potential that they might be very happy to take a lower paid position as opposed to the alternative of not having a job. This point is very consistent with unfair dismissal cases. An employer should not assume that the employee is not interested. Okay, the next point about when should consultation commence. It's important to refer to the relevant industrial instrument on this one. As I said earlier, so it's next slide, the clauses in awards are usually the same. So I've got there on that third dot point, the standard modern award clause. And in that instance, it says where an employer has made a definite decision to introduce major change. So the definite decision is when you need to consult under the modern award. In the Scott decision, there was some divergence, and this is an interesting complexity between the two different areas, really. Basically, the Scott decision said, and I'll just refer you to the part highlighted there. It says, this inherently requires the employer to discuss the proposed change and to genuinely consult affected employees before the definite determination has been made. I think that generally in the employment cases, you'll find that the modern award requirements are the minimum. What I would say about this divergence and the complexity around it is that it is quite difficult to know when you start consulting with employees if there's no point of a definite decision. One thing that made it fairly unique in these circumstances was the Scott particular circumstances, really, is about the fact that he had been on long-term sick leave. And I'm going to go into in a bit more detail. No one had discussed with him any performance concerns, things like that. My preferred point and my general recommendation would be I would suggest that you're better off starting to consult once a definite decision has been made, as per the modern award or whatever your enterprise agreement says. So definitely go back and read that to be sure that you're meeting those requirements. But if there are particular circumstances that apply to your case, then you may need to consult earlier. So for example, if you're conducting a wholesale review of a work area, it just makes sense that you would want to consult with employees during that review process. And then again, if there are particular circumstances affecting an employee like Mr. Scott, then you may wish to start consulting earlier. So the next point I'm going to make is about unaddressed performance concerns. So one point that was made in the Scott case that is somewhat related to consultation in that it needs to be about the genuineness of the redundancy. So what are the contributing factors to deciding whether a redundancy should take place for management? One of the contributing factors in this case was Mr. Scott's performance. It was said in the Scott's case that one of the things the general manager looked closely, one of the things that caused him to look closely at the plant structure was complaints that Mr. Scott had been handballing his duties to the day and afternoon shift operators and that he hadn't been keeping up with his administrative duties. And so this made it look like his duties were significantly reduced. The Commissioner remarked that there was no clear evidence whether or when these concerns had been put to him and whether he'd had an opportunity to respond to any of those. And this contributed to the Commissioner's finding that the redundancy decision was not reasonable. So essentially we're talking here saying that a redundancy should not be a de facto performance management situation. Usually, as per any performance management situation, you need to speak to an employee if you've got complaints or concerns as they occur, and definitely prior to any talk of redundancy. This allows the employee the opportunity to address concerns to the extent that they can. This part of the decision was actually quite similar to a previous decision from South Australia, Befalco, which I've got written up there. In this matter, the employer realised that there were significant deficiencies in the employee's skills and performance, but these were never discussed with the employee. He'd been employed at this particular employer for a significant period of time, like 10 years or something like that, and been promoted a number of times. They did, however, commence a review of the organisational restructure, at least partly due to the employee's performance concerns, and they never consulted with any of their staff on this. The review ended up recommending a streamlined structure, and following the review, over the next 2 months, management redesigned Mr. Befalco's position without speaking with him. And in the end, the new position ended up being very similar to his position, but required a high level qualification. So he was essentially made redundant because he didn't have this qualification. He didn't apply for the job. It was held that a redundancy based on this, where the employee had not had an opportunity to respond to concerns or an opportunity to provide input into the process, was not reasonable management action. And then the last point here is a fairly basic one. It's just that misrepresentation of his employment security. And Anna touched on this earlier. There were a couple of times when Mr. Scott was led to believe that his employment was safe, when in fact it was not. And this is due to, and as we talked about earlier, there was some context where he was actually worried about his employment security due to his length of absence due to illness. So there was 2 times when it was said that he was given some misrepresentation. There was comments by the CEO during a company-wide video link. And there was also some comments in a letter regarding his capacity to return to work. Unfortunately, because there was no early consultation and there was no discussion with Scott about his performance, and then there was his misrepresentation, this resulted in what the Commissioner called a big shock to everyone, when in August of 2018, he was made redundant on the spot. So all of these cases seem to point to a similar point of the fact that the actual termination should not come as a big shock in redundancy. There should be at least something to point to the possibility of redundancy in order for an employee to make time to make preparations for a redundancy. Anna's got a couple of other reasons why it wasn't reasonable management action, so I'll pass on to her now.
Thanks, Adele. So the things that Adele has just spoken to you about really relate to the first limb of the reasonable management action exclusion, and that is the kind of substantive reasonableness of the management action. But there's 2 limbs to that exclusion, and both of them need to be satisfied in order for the exclusion to apply. The second limb is that the management action must be taken reasonably. And as you've probably guessed, that relates to the process rather than the substance of the management action. And the employer in Scott fell short in relation to this limb also. In particular, the worker was not notified of the purpose of the meeting in advance and was not afforded the opportunity to have a support person at the meeting. Now, the calling of meetings often comes under scrutiny in the context of the reasonable management action exclusion. And so I think it's worthwhile just having a look at some of the surrounding case law in that regard. Now, I know that there may be very good reasons not to give too much notice of the purpose of a meeting. We all have stories of the employee who immediately prior to termination deleted a whole lot of important emails, stole confidential information, or maybe just ran around poisoning the well. Despite this, we have had clear and consistent guidance from the Commission that failure to notify the purpose of a meeting and offer a support person is not reasonable. And so I want to give you a few recent case examples because this comes up so frequently. Imagine yourself in this situation. You're calling a meeting to discuss suspension of a worker pending the results of an investigation. Do you, A, give them notice of the purpose of the meeting and offer a support person? Or B, ask them to the meeting without notice and only offer a support person once the meeting is underway? If you picked B, you're not alone. You made the same decision as the employer in the recent matter of Mayer against the Workers' Compensation Regulator. In that case, the Commission found that although the decision to suspend pending the results of the investigation was reasonable, the way in which it was achieved was not. The failure to provide notice and offer a support person meant that the otherwise reasonable management action was not taken reasonably, and the exclusion in section 32 sub 5 could not apply. That decision can be contrasted with the decision in Queensland Nurses and Midwives Union of Employees and the Workers' Compensation Regulator. That is a 2020 decision. It was recently appealed, but the 2020 decision was upheld on appeal. And in that one, it was found that it was not necessary to offer an executive level employee a support person in a meeting about mutual separation. I should say that I feel that that decision stands alone. It related to an executive level employee and was in circumstances where the worker had previously raised the option of mutual separation. She also had a fair bit of notice regarding the purpose of the meeting, such that she had actually taken some advice on the topic to be discussed, and she could have arranged a support person during that time had she wished to. I think the more consistent approach has been to require the notice of the purpose of the meeting and the opportunity for a support person. This was reiterated in another recent decision of Grace and the Workers' Compensation Regulator. Now, when it comes to support persons, there's often debate about whether you have to proactively offer a support person or just give the worker enough information to realise that they may need one. One benefit of offering or suggesting that the worker obtain a support person is that you are in a bit more control of the process. You can specify that it be someone external to your organisation if that's what you so desire. You can also require the notice of the identity of the support person and be prepared accordingly. I'm sure many of you have had a situation where the support person who turns up is the worker's best friend barrister, and it's nice to be on notice if that's what's going to occur. So the Scott decision really is consistent with the surrounding case law as it relates to the calling of meetings, and the takeaway points from that are to provide sufficient notice of the meeting itself and of the purpose of the meeting, and to provide the opportunity, whether that is proactively or simply by providing enough information about the purpose, that a support person can be obtained if necessary. Now, if we just recap, and perhaps I'll ask you, Adele, to distill all of that down into a few key takeaways.
Thanks, Anna. So these are sort of a summary of what we've spoken about. So the first one is to be confident that the redundancy is genuine and don't mix it with performance concerns that haven't been addressed. The second one is an interesting point. And so I was reflecting on the fact that why these people started thinking about the fact that it might be performance related when nobody had spoken to them about their performance. And so how did they even know that the decision was performance related or that had some influence on it? And Anna and I thought about the fact that when you've got a single position redundancy, it does look a lot more suspicious that that person has been targeted for some reason. So while you need to be careful with all redundancies and making sure you're covering off on all of these points for all redundancies, you do need to be careful with single position redundancies because they do create some scrutiny when one person is chosen and nobody else is. The next point there is know what the relevant consultation requirements are, and if in doubt, consult. So there certainly is a lot of information in your awards, in your enterprise agreements that says what exactly you should do to consult, and you need to be very, very careful to cover off on all of those. And as this decision suggests, you're best off just consulting, even if you don't think that an award or an enterprise agreement applies. We talked at some point about deciding when the consultation process should commence, and that needs to be, at the very minimum, it needs to be once a decision has been made to introduce a major change. But in some instances, you should consult earlier if you're doing a major workplace review or if you are dealing with particularly sensitive employees who've been through long-term illness or something like that, similar to the Scott case. Be very careful about what you're communicating about employment security if it may not actually apply to all people, which is what happened in the Scott case. And then for the last 2 points there, so reasonable management action, this is what Anna was talking about. Make sure you give notice of the meeting and the purpose of the meeting. That doesn't need to be the purpose being we're making you redundant. I think that is not the level that is required. What we would often recommend is that you talk generally. So it might be something like that you want to talk about an organisational restructure. It might be that you want to talk about the person's employment. That's the kind of notice we're talking about. Something that gives the employee an idea that this is a serious discussion, but not to the point where you're saying to them, we're going to make you redundant. So giving them the opportunity then to delete all the confidential information and send it away to their own private email address. And then the last point there is make sure that you offer a support person. Interestingly, under the Fair Work Act with support persons, there's only a requirement to agree to a support person if someone asks. But these WorkCover cases are, again, raising that bar where you need to make the offer to the person. And as Anna suggested, I generally think that that's a very good idea because in my experience, a support person can actually be beneficial to an employer as well. They can be someone who's there, if the employee is particularly upset and you're thinking, oh, how am I going to send this person home when they're in a ball of tears? You've actually got their support person there who can help you take care of that. And the other thing is that support persons often help clarify by asking questions, and while they're not there to advocate for the person, their ability to help a person who's in a time of great distress can be really helpful to an employer. So my general recommendation is to offer a support person wherever you can in instances where you think the employee might become upset. And that'll help both your fair work requirements or your industrial requirements and also your WorkCover reasonable management action requirements. Did you have anything to add, Anna?
No, I think you've got it all. So I hope those takeaway points have been really helpful for everyone. I think we've received a few questions during the course of the webinar.
Yeah, we might, listeners, stay on the line for a couple of minutes. We'll just let Adele and Anna gather their thoughts in response to some questions that were submitted. So we'll just pause for a couple of minutes, but we'll be back momentarily to answer those questions. Okay, thanks for being patient with us. I'm going to hand back over to Adele and Anna. They'll just explain what the question is and then provide their expertise in response.
No pressure. Thanks, Hannah. We've had some really good questions though. There was one which was, how do you manage a need for redundancy of a worker with an accepted WorkCover claim and section 232 capital B of the Workers' Compensation and Rehabilitation Act, which states that an employer must not dismiss the worker solely or mainly because the worker is not fit for employment in a position because of the injury. So the moratorium essentially on dismissal during that time. I guess it comes back to the genuineness of the redundancy. If the redundancy relates to a business need, then it would be difficult to construe how it could be infringing on that section, in the sense that it's not solely or mainly because of the worker's fitness or otherwise for that role. The risk, of course, is that a worker in that situation may perceive that the redundancy is not genuine, but in fact due to that injury. And so perhaps you're sitting in a risky position in terms of some kind of action by that employee.
What I would just add to that is that in my experience, one really good thing to do to help you, in some respects, you need to convince the employee that the redundancy is genuine to ensure that they don't then go and take litigation against you. And when I say that, I am often inclined to write possibly, bigger letters than what you would do otherwise, but a decent long letter that explains to them exactly why the redundancy is important, it needs to take place, and then also explains why you've listened to, or how you've listened to the concerns they've raised, how you've listened to the possible other options that they may have raised, and respond to all of that. So if you can do all of that in writing, preferably, and in a way that's really clear, then that'll help the employee process the idea and come to the idea that there is actually a good business reason. And then it may also even help with, if that employee takes that letter to another lawyer or to someone who might represent them in an unfair dismissal, for example, or in a claim against work, in this case, or under that section of the WorkCover Act, then that lawyer will look at that documentation and go, oh, I don't know about your claim. Whereas if you haven't put all that in writing, responded in writing, then the employee's memory of what's gone on is what you're relying on. And that's no one's memory is entirely accurate. And particularly when you're in a situation where you're particularly upset. So my recommendation to avoid that is to get your documentation really clear, make sure the employee has copies of that so they can process it at their own time.
And I think that probably ties into one of the other questions that we've had, which is a request for practical advice for employers managing a redundancy so as to avoid or try to avoid the worker lodging a WorkCover claim. I think if you've taken those steps of consulting appropriately, being fairly transparent, perhaps documenting the information that Adele has just suggested, ensuring that the meeting is called with appropriate notice of the purpose and the involvement of a support person, whilst you can't prevent someone from bringing a WorkCover claim, maybe that goes a long way to putting them in the right frame of mind to understand why the redundancy is occurring, and to be disinclined to bring a claim.
And I guess that goes to the underlying thought of, we're not necessarily looking to avoid them bringing a WorkCover claim, we're looking to avoid them having an injury. And so you need to do whatever you can to support the person through the process. And that's about being kind and compassionate to the extent that you can, knowing that the person's going through a difficult situation, helping them exit in a nice way to the extent that you can, going away parties, whatever, things that just make the end process not as traumatic as in the Scott case, where he was given, no notice, turned up and was walked out of the building. So clearly that's going to be the more traumatic of the options.
Yeah, and speaking of avoiding injury, which is obviously what we're all trying to do, one of the other questions we have had is, should an employer offer EAP, so an employee assistance program? It never hurts to offer that. All it is putting the employee on notice that the EAP is available, and perhaps giving them the details of how they can access that. I have had employers say to me that they worry about doing that because it might suggest to the worker that they might have a psychiatric injury. I think that you're better off taking the kind and compassionate route, and making the offer of that service so that they know it's available for them to access if they need to. I don't think it triggers anyone bringing a WorkCover claim.
Look, honestly, it's the last line of just about every letter that I write for employers to employees. There's no good reason to not offer it whenever, wherever, just offer it, is my view. Okay, the last question that is probably is a little bit more in my field, which is, should an employer have their redundancy policy published and available to staff to read? I think that there is no requirement that any employer has a redundancy policy. And in my experience, particularly in the medium, small size businesses, most businesses don't have redundancy policies, and I don't think that's a problem at all. We've got the guidelines that you apply to redundancy policies are these modern awards, these enterprise agreements, and just general what's reasonable management action. So I would suggest it's up to the employer whether you want to have them available. There's always considerations with policies. You need to be careful that they're not part of the employee's contract. So there's a whole range of different employment questions that can come out of that I'm not going to go into now. But if you're going to have a redundancy policy, you need to be really careful that you are very, very happy to comply with it and that you do comply with it. Any kind of policy that you have up that you then don't comply with will leave you open to all sorts of scrutiny. So I guess that's really the answer to the question, is you don't have to, but if you do, make sure that you're very happy to comply with it and that you do comply with it.
Adele, I'm just going to throw you another question that's just come in.
Yep.
When a company restructures and does redundancies, sometimes they put alternative employment options on the table, like maybe part-time or things like that. Does the notice period requirements change at all in terms of making a different offer of employment as opposed to a redundancy?
That's a good question. And probably there's a little bit, it depends, the good old lawyer answer. If the position is, if the person's going to be changing their salary and significantly changing their location or some kind of significant change to their employment, then I would definitely be giving them the same amount of notice that you would give to someone who was being terminated. So that depends on the particular contract you have with them, but usually it's somewhere up to 4 weeks, maybe 5 weeks, unless you're in a more senior position. So in those positions, you'd give them that amount of notice usually at that level. But if it's, pretty much the same, similar position, similar salary, then perhaps you wouldn't. But I guess, again, it's about what's reasonable for that particular situation. Does that person need some time to adjust to the particular changes or anything like that? I'd err on the side of giving them the same amount of notice unless the employee's happy to move, really.
That's true. Too easy. Thank you. Okay, we might conclude it there. A big thank you, Adele and Anna, for presenting to us today. We appreciate your time and effort that you put into preparing and presenting. We know it's a big ask. To our audience, thank you again for tuning in this morning. I definitely found it helpful and informative, so I'm sure you did too. As mentioned earlier, this session is recorded, so we'll send you out a link to the recording early next week, and it will be on our YouTube channel. That's all from us here today. Please keep an eye out because we will shortly be sending out the next details of our November webinar, which will be our last webinar for the calendar year. So watch your inbox and LinkedIn for that one. Thanks everyone. Have a great day.